Can I stop paying alimony if my ex is living with someone? Hi, I'm Bill Farias, founder of Farias Family Law. We met with a gentleman a couple of months ago. He has been divorced for 5 years. He's been paying alimony, and he just recently learned that his ex has been living with someone for about 4 months. He believes it's a boyfriend, but he's not sure. And so this is the way that this issue is treated in the family law courts. First of all, it's referred to as a cohabitation issue. And where this comes from is that in 2012, Massachusetts passed a new alimony law, and one of the provisions of that new law is that if there has been cohabitation for at least 3 consecutive months, then the payor may be entitled to a modification or even a termination of the alimony order. And so there are a few things to keep in mind. First of all, you can't just stop paying alimony. Unless the terms are clear in your divorce agreement, if you think the order needs to be changed, you actually have to file a modification. Whether you're entitled to a modification is what we're going to cover in this video. So the first thing you need to do is you need to look at your divorce agreement to determine whether alimony is modifiable. So depending on what you signed, your alimony order may have merged into the judgment of divorce, which means that it remains open and modifiable, or that particular provision may survive the judgment, which means that it's closed forever. And so you have to look at the specific language. There is usually a provision in the agreement that indicates which terms merge and which survive. And if alimony merges, then it's open for modification. You may also want to look in the alimony section specifically, because that usually indicates whether that particular provision remains open or is closed permanently. So if it's closed permanently, then you cannot modify. Your ex can live with someone else, your ex can live with a dozen people, and you are stuck generally with the terms of that order, absent extreme circumstances that are really not worth going into here. But just generally, if it merges, it's open. The other thing to keep in mind is that if your agreement was finalized before March 1st, 2012, which was the effective date of the new law, then you cannot take advantage of the cohabitation provision in the new law. So this is the state of the law as of today. We're in July of 2021, and the current state of the case law is that if a divorce judgment was finalized before the new alimony law went into effect in March of 2012, then those old cases are not eligible for modification under this new provision. So that's unfortunate, but that's how it works. So you have to look at the date of the judgment. If the date of the judgment is March 1st, 2012 and later, then you are eligible. Next, if you clear those 2 hurdles, you have to look at the specific facts of the case. And to do this and to determine whether you qualify, you may want to run this by an experienced family law attorney to make sure that it's a good idea to file, because you don't want this to backfire. In other words, if you file and you're not eligible for modification, then you may be opening up a can of worms. The other side might counterclaim, and you don't want to get into that. So first, double check with an attorney to make sure that your circumstances are good for a modification. And so some of the factors that the court would look at is, first of all, there has to have been 3 consecutive months. So you need to be able to prove that your ex has been living with this individual for 3 consecutive months. And so some of the ways that people do that is they can hire a private investigator to go out there and, for example, take some pictures of a car in a driveway early in the morning and late at night, We sometimes have investigators run database searches because sometimes these people who have moved in end up on utility bills, and that's a good indicator that the person lives there. But you want to make sure that you have the goods. You want to make sure that you have the evidence that supports your position that the person has been living there for 3 or more months. Some other factors that the court takes into consideration is whether these individuals are holding themselves out as a couple. Are they financially intertwined? When it's not really clear yet whether there is a requirement for there to be an actual sexual relationship. So for the most part, the bar understands this to be a boyfriend-girlfriend type arrangement, but there isn't clarity yet from the higher courts on whether that's the case. But the factors lead you to believe that it is, because the court's going to look at whether these people are sort of acting like a couple, whether they are dependent on each other financially, and a few other factors. So you want to run this by an attorney, and if you have a case that is a good fit for a modification filing, then you proceed with the filing and address that issue in court. So whether you can stop payments based on your ex living with someone else, first, does your alimony provision merge with the judgment? If so, it's modifiable. If not, and it survives, then you're stuck. Number 2, was your case finalized after the Alimony Reform Act effective date of March 1st, 2012? If it was after, then you're eligible for modification. And number 3, do you have the factual basis? And to figure this out, you're better off going through it with an attorney. But the bottom line is, do not just stop your alimony payments. Even if you're eligible, you have to file a modification. If you have any other questions about this, you can call us 508-675-0464. You can email us at info@fariasfamilylaw.com. If you found this video helpful, you can subscribe to our channel and share it with anyone you think might benefit from it. And you can also find us on Facebook and Instagram at Farias Family Law. Thank you. Have a good day.